This final lecture gives us an opportunity to wrap up a few remaining items from earlier in the course, and then some concluding remarks about deportation and national security, the topics for this week. I also want to remind you that many of the topics we have considered over the past few weeks are quite intricate in detail, and we have omitted much of this detail in order to provide a general overview. Let's look at one issue that I would like to bring to your attention with respect to temporary visas, which we looked at in weeks 3 and 4, and that is special rules for Canadians and Mexicans. This is not a detailed look again, but it's important to know about. The North American Free Trade Agreement, also known as NAFTA, created a special visa category for Canadians and Mexican citizens who wish to work in a profession in the United States. It's called a TN visa, and it's similar to the H-1B visa that we discussed in prior weeks. The difference is that Canadian citizens do not have to file labor certifications, or the employers don't have to file for those, or labor attestations. Somewhat controversially, however, those requirements are still in effect for persons from Mexico for the TN visas. Other provisions streamline the entry process for both Mexicans and Canadians. Most Canadians under NAFTA may enter with only a passport. Canadians and Mexicans also may visit the United States with what is known as a border crossing card, which contains biometric data. Mexicans may enter the United States with this card for up to 30 days at a time, and they may travel on either business or pleasure up to 25 miles within the United States border, or in the case of Arizona, up to 75 miles. Another item that I would like to revisit, because it has arisen on the discussion boards, is the question of membership in the Communist Party and United States citizenship. I want to show you the statute. I won't read it to you, but you can see it here on the slide. But essentially, Congress has decided that members of the Communist Party, with an extended definition of that, whether it's the Communist Party of the United States or communist parties abroad, may not become United States citizens. They may not naturalize. These also can serve as grounds of inadmissibility, and that's a reminder to us of Congress's plenary power over who may enter and who may stay within the United States. I would like to add the note that the Patriot Act has extended these definitions, as we talked about in week 3, to include many very expansive definitions of terrorism. Now we're turning to this week's topic, which is immigration court proceedings, deportation, and national security. I want to go into somewhat more detail some of the issues that I talked about with our guest Amna Shirazi in earlier lectures this week. I'd like to begin with proceedings in immigration court and what constitutional rights apply. The constitutional right of due process, as we know from the 14th Amendment, applies to all persons, applies within immigration proceedings. What does due process require? The minimum standards, the Supreme Court has said, are notice of charges and a meaningful opportunity to be heard. So those are minimum standards. Congress can vary them by adding to them, but may not go below that specific floor in dictating procedures that immigration courts will follow. There is a right to an attorney if you can afford one, or if you can find a volunteer attorney. You have the right to bring one with you to immigration proceedings. But if you cannot afford one, you do not have the right to have one appointed for you. This is a point that we've made earlier, in the sense that this is different from constitutional criminal law protections in the United States under the 6th Amendment. There's one additional Supreme Court case that I want to bring to your attention. It's known as Padilla versus Kentucky, and it was decided by the United States Supreme Court in 2010. Its basic holding is that criminal defense attorneys must advise non-citizen clients about the deportation risks of a guilty plea. This, again, is related to the Sixth Amendment right to counsel in the criminal context. This is a very significant decision for a number of reasons. One, it requires criminal defense attorneys who have non-citizen clients to understand some basics of immigration law or to consult with an attorney who does. The Supreme Court said that this holding is not retroactive, so it only applies to cases decided after the decision was handed down in 2010. The other significant issue here is that it may signal an interest in the United States Supreme Court to provide counsel for attorneys in immigration proceedings. A federal district judge in California, as we noted in a prior lecture, has recently ordered that attorneys must be provided for mentally disabled persons who are in immigration proceedings. So Padilla versus Kentucky may signal a broader interest by the United States Supreme Court in the quality and availability of representation in deportation proceedings. Now I'd like to return to the grounds of deportation. This is a slide that we saw in an earlier lecture this week, and I want to go over it in some additional detail. You see that it represents charges in immigration court, and we said entry without inspection, that is, surreptitiously crossing the border in some fashion. Entry without inspection constitutes the majority of grounds of deportation, and we said that entry without inspection constitutes the majority of the deportations in immigration court in any given year. Combined with that are other immigration charges, but I want to discuss in more detail criminal charges. It's a significant portion of immigration deportations, and these are crimes that have been committed once a person is in the United States. Let's take a look at some of the most significant grounds. Deportation is mandatory for all aliens and legal permanent residents sentenced to a year or more for aggravated felonies, moral turpitude, or controlled substances. Recall that we said these would also be grounds of inadmissibility if these crimes were committed outside of the United States, and in fact, many of the grounds of deportation mirror the grounds of inadmissibility that we discussed in Week 3. Since 1996, in the Illegal Immigration Reform and Immigrant Responsibility Act, deportation of legal non-residents has been much faster and more frequent by considering increasingly minor criminal offenses to be automatically deportable. This trend has continued with the Patriot Act and in subsequent legislation. I also want to return to the topic of expedited removal. In the slide that we were just viewing, those immigration grounds of deportation do not include persons who've been removed by expedited removal or those who have left under the concept voluntary departure. In this next slide, I show the full definition of expedited removal. I won't go over it here, but I encourage you to take a look at it. As we said, it's a process of removal that does not involve the immigration court. It is a summary process by which one federal officer can determine that you are ineligible to enter the country, and it is mostly used with entry without inspection. But it can also be used whenever a federal official believes that you are holding, possessing, or using false documents to obtain admission into the United States. Let's look once again at a slide we saw in an earlier lecture this week. This is called the Constitution-Free Zone of the United States. You may remember that we talked about this as a 100-mile zone. Congress has, by statute, given to Border Patrol agents within 100 miles of any land border the authority to use expedited removal on persons who are found within that zone. We also said that Congress has authorized warrantless searches in some instances also within that 100-mile zone. What is the significance of expedited removal? Well, let's look at some recent data. Expedited removals, and again, that's no hearing before an immigration court. These were the second largest category of all ICE deportations in 2012. Nearly 1 in 3 deportations are expedited removals. And if you add to that voluntary departure, Nearly half of persons alleged to be in violation of immigration laws are deported by the decision of a federal agent and not by the immigration court. So I wanted to bring these to your attention because the chart we saw earlier dealt only with deportations through immigration court. So I wanted to bring these to your attention because the pie chart we saw earlier dealt only with deportations through immigration court. And it is also true that Mexicans are disproportionately subject to expedited removal. This shows the number of removals of Mexicans by U.S. authorities, that's in the thousands, for the prior decade. This statistic does include expedited removals. So finally, I'd like to turn to national security. Let's take a closer look at efforts to enhance national security in the immigration reform bill. Here are the key compromises in the proposed Senate bill. Number one is enhanced security. Enhanced security is linked very closely in this bill with legalization for undocumented persons. And then finally, the third prong of the key compromise is a guest worker program. This guest worker program is for lower skilled employees, and it was the result of an agreement between business interests and labor unions. This raises the question of the economic impact of the presence of nearly 11 million undocumented persons in the United States. Academic scholars disagree about whether there is a net positive or a net negative benefit in economic terms. It's a question we have not really considered in this course, but it includes whether the presence of undocumented workers lowers the wages for American workers. Although we haven't discussed this in detail, I urge you to use caution when you encounter arguments about the economic impact. And this is because, as I mentioned, academic scholars themselves do not agree on the appropriate numbers that are relevant. So the three prongs again, the key compromises in the Senate bill, enhanced security, legalization, and a guest worker program, are tied together. And let me just show you some provisions. You'll recall at the end of week 4, we had a brief overview of immigration reform in the bill, and I would like to show you again a summary of what those aims are. The bipartisan Senate committee released a statement in which it said, one aim is to, quote, create a tough but fair path to citizenship for unauthorized immigrants currently living in the United States that is contingent upon securing our borders and tracking whether legal immigrants have left the country when required. So there you see the very clear link between enhancing border security and the path to legalization. This was a key part of the compromise. What does it do specifically in terms of enhancing that security? Here are some examples. The bill explicitly provides additional funding and substantial funding for Border Patrol, technology for surveillance, including unmanned aerial vehicles, also known as drones. It creates a Southwest Border Commission that includes governors and other local officials along the border with Mexico who will be tasked with determining safety measures as well as security of the border. And then this final note from the bipartisan Senate group, quote, we will demonstrate our commitment to securing our borders and combating visa overstays by requiring our proposed enforcement measures be complete before any immigrant on probationary status can earn a green card. So there the link is very clear, and one criticism of this bill is that it postpones any legalization by way of green card for the undocumented aliens into the quite indefinite future. One might also note that an enhanced ability to track persons who are in the country legally or not does not necessarily make the country safer. The exit system, for example, would alert the government to someone who has overstayed a visa, but it does not tell the government whether that person is dangerous. and therefore for national security purposes, the intelligence agencies, the FBI and the CIA, serve a far more important role than a visa tracking system, in my opinion. So my prediction for the future of immigration reform is very much centered on an interest in national security and an interest in border security, and only secondarily does it seem to be focused upon undocumented workers. This is the end of this lecture and concludes the course. If you have made it this far, my congratulations to you. The discussion boards have been lively and informative and provided an integral part of the learning process by some valuable contributions. So thank you for your participation. I want to leave you with one final thought. When the 1952 Immigration and Nationality Act was under consideration, and remember, we are still basically working with the 1952 INA, Immigration and Nationality Act. When this was under consideration in Congress, the Director of the Budget, as it was then called, wrote to the Secretary of State, who was Dean Acheson, and wrote the following thoughts. And if you'll indulge me, I wanted to read from that letter. These bills raise fundamental questions with respect to the treatment that should be accorded aliens who seek to enter this country and with respect to the position aliens should occupy in our society. In this connection, much has been made by the proponents of these bills of the fact that as a sovereign nation, the United States can admit as many or as few aliens as it chooses on whatever terms and conditions it deems desirable. The conclusion drawn from this is apparently that aliens have no rights. We do not believe that that conclusion is sound or that it provides an adequate basis upon which to construct immigration and naturalization policy. The letter concludes with the following. We do not believe that aliens differ in any fundamental respect from other human beings. We believe that the worth and dignity of all individuals, citizens or not, demand respect. And we believe that it is particularly incumbent upon the United States as a democracy to guarantee that that respect shall be paid. Our willingness to offer such a guarantee is the measure of the strength of our professed beliefs. I hope that you will participate in immigration reform debates in an informed fashion, whatever your views may be. And thanks again for taking this course.
The preceding program is copyrighted by Emory University.